Welcome to the Roberts Law Office Injury Podcast. Kentucky attorney Jeff Roberts has over 25 years of experience. He'll provide answers to your questions related to personal injury and automobile accidents, workers' compensation claims, and Social Security disability benefits. Let's join Jeff for this episode.
Friends, we are back in Murray, Kentucky, down in Callaway County with personal injury attorney Jeff Roberts. And today we're going to talk about 5 things not to do after you've been in a car wreck. Jeff, how are you?
Doing good, Jim. How are you?
Buddy, I'm doing fine. First time we've actually done a video podcast actually in your office. So here we go. Another string of firsts for us.
That's right.
Fantastic. Yes. Well, okay. So you've practiced injury law for over 33 years now.
Correct.
And you've done cases all across Kentucky. You know, there are a lot of blogs. In fact, we've probably already done a podcast on things you should do at the scene of an accident. But today we're going to kind of mix that up a little bit and talk about the things you should avoid doing.
Correct.
So based on that, what would be the first thing somebody should consider not doing at the scene of an accident?
First thing is you should not let the other driver talk you out of calling the police to the accident scene. It's very important to have the police come out to the accident scene. I've had clients come in or potential clients come in and say, you know, they were rear-ended, wasn't that much damage to the vehicles, and, they didn't realize they were hurt at the time of the accident. And the other driver said, look, let's just exchange insurance information. There's no reason to call the police. I rear-ended you. And they exchange insurance information.
All of these important statements.
Yes. And then go about their ways. I've had them where the driver that did the rear-ending actually told their insurance company, yes, I rear-ended the person, and everything went fine, even though there wasn't a police report. But I've also had it where the other insurance company, when I reached out to them, said, that's not what our guy said happened, and it's much more difficult in that situation. If you call the police, have the police come out to the accident scene and document everything. They'll talk to both drivers. They'll either take photos or they'll have body cameras on that will show where the vehicles are, and show that yes, your vehicle has damage to the back end, the other driver's vehicle has damage to the front end. You were on the road where you were supposed to be, etc. And it just helps move everything along, makes it much smoother, much easier, much less litigating when you have that police report. It doesn't mean that it's always going to not be litigated, but if you have the police report that documents everything, that makes it a lot easier down the road if you weren't the at-fault party in establishing that you were not the at-fault party in the wreck.
Now, in the example you gave earlier, when you said that the other person said, hey, sorry, I rear-ended you, we don't need to, you should tell the police officer that, right? That this guy said he actually did this to try to get that on the police report. Is that correct?
Yes, I would say that to the officer. Yes, that he already acknowledged that he rear-ended me. And so you let the police officer know that so that they will, if they haven't already talked to the other driver, when they talk to the other driver and ask what happens, if he says something different, then they can say, well, this guy said you already told him you rear-ended him, and then hopefully things will go quicker and he'll correct his misstatement if he did make a misstatement to the police.
Okay, that makes sense. So of the 5, that was number 1. What's the second thing you should not do at the scene of a car wreck?
You shouldn't admit fault. So if the other driver says I rear-ended you, that's fine, but you should not admit fault at the scene. You should not say you're sorry at the scene of a wreck. A lot of times when you're in a wreck, you're sorry the wreck happened.
Right.
Even if you aren't the one who caused the wreck, you're still sorry that the wreck happened.
And it's a normal response, I would think.
It is a normal response. And I've had times where clients have said that. They come in and told me, said, I think I said I was sorry at the wreck. Is that going to bother me? And at one point in time, it probably wasn't that big of a deal because, most of the time the officers don't really document that in their police report. So if you tell the officer that that's not, and it doesn't make it in the report, nobody even knows you said it. Even if you tell the other driver, if it's not in the report, probably, probably not going to be a huge deal. But if it's a question of who was across the center line on the road, especially if you're out in the counties in western Kentucky. A lot of the county roads do not actually have a center line. So who crossed it over into the other person's lane of travel can be a question that's hard to answer at times. And I've had a situation where I've got where it comes in now more frequently is because police officers have the body cameras. And so it's not just they put it down or don't put it down on the report, but you saying, I'm sorry, is on a body-worn camera, and I can assure you that's going to be shown to the jury if the case goes to trial.
Right.
And so if you say, I'm sorry, or I'm at fault, or I did something, that's going to, especially when with all the police now, or most of the police having body cameras, that's going to be recorded, and I can assure you that if the defendant does that, I'm showing that camera, that video to the jury early and often. And if it's the other way around, the defense attorney is going to show the plaintiff saying that early and often to the jury.
Even though it may be slightly out of context, it's still, hey, look, this was a statement made.
Yes.
And then they have to defend why they said it. And now you're going down a whole different rabbit hole that you'd probably like to avoid.
Correct. If you can avoid having to go down that rabbit hole, then you're much better off. Should it make a difference? Probably not. But if you've got a situation where you've got competing experts and the jury doesn't know which experts to believe on where the accident occurred in the roadway, and one side says, I'm sorry, and the other side doesn't, that could be what tips the scales for the other side to be successful in that case.
Well, and it's interesting. You said if it were to go to a jury, because a lot of these cases actually settle before they get to court. But I would think if I've got a video documentation of somebody saying, I'm sorry, you're going to use that in the negotiations back and forth, whether it's you or them. It's going to be put to work.
Correct. The insurance company is going to, if it's the defendant saying it, the insurance company is going to get that video from me when I make a settlement demand in the case. And but the insurance company, when I get involved in a car wreck, one of the things I do is obtain all body cam footage. From the police officers that were on the scene, and the insurance companies are doing the same thing. They're getting that body cam footage as well, so they already know their insured said I'm sorry at the scene. They're not going to tell me most likely that their insured said that. But if my client's the one who says I'm sorry, I can assure you that when I get a response back to my settlement proposal, they're going to say, well, your insured admitted he was at fault by saying he was sorry at the scene of the accident, so we don't really think we're at fault, and we may offer a little to make it go away, but it can really affect the value of a claim.
Yeah, it can mess with the leverage of the facts. Really.
Yes.
Okay, that makes sense. All right. So again, if you're at an accident scene and you've been in a car wreck and you're wondering, what should I not do? We're talking about 5 things that you should avoid doing at a car wreck. So let's go on to number 3.
Number 3 is do not assume that your injury is temporary or minor and fail to seek medical treatment. That is something I face frequently when I talk to new clients. Is they thought, well, I was a little sore later that night. At the scene, a lot of times you're not feeling anything because you've got so much adrenaline pumping through you, and that takes over in everything else going on, and you're really not focused on your health if you're hurting or anything else at that point in time. And a lot of times it develops a little later on in the day or the next morning, and you realize that you're sore and you got some pain. But frequently people think, well, it's not too bad. I'll take some aspirin or Tylenol and it'll go away, and they don't seek medical treatment.
Walk it off.
Exactly. And then a month later, it's still there, and they finally go seek medical treatment, and then we have to explain that to the insurance company or to the jury if we go to a trial in that case. And, sometimes the client is helpful and they tell the doctor when they finally go seek medical treatment that I had this wreck a month ago. I was sore the next morning, and it's just kind of gradually gotten worse since then. I thought it was going to get better, but it's gotten worse, and I thought, well, I need to get in to see somebody. If that shows up in the medical record, it makes my job a whole lot easier.
Right.
But a lot of times it's, I had this wreck a month ago, and I'm having this pain, and it doesn't explain why they didn't seek medical treatment earlier.
And if I'm the insurance company, I'm going to say, well, did you do some yard work? Did you, play some athletic sports or something like that? There could be other things that are not related to the wreck that actually are causing the pain. So again, I've got leverage now.
Exactly. That's exactly what they say is, how do we know he didn't do something else in the month after the wreck? Before he sought medical treatment that caused this, and then he just realized, well, I can blame it on the car wreck and get some money. And so that's the reason one of the reasons you don't want to wait on seeking medical treatment. The other reason you don't want to wait is frequently with injuries, the sooner that it's treated, the better your recovery is.
That's a good point. You've made that statement before in previous episodes.
Yes, and so getting that early treatment can make a difference in the ultimate recovery, and I would rather my clients get treated early, get as good as they can possibly get from the injuries, and not have permanent problems from an injury because they sought treatment early for the injury than wait and then have problems or greater problems because of that.
Yeah, down the road there.
Yeah.
Now, Jeff, I know a lot of us are probably thinking, well, okay, if I have to go to the hospital or I have to go to urgent care or the ER, that's a medical bill. And I don't know if I can afford that right now. Maybe I'd be better off just kind of seeing how it goes. But we've talked about this before. Kentucky has something called PIP insurance. Do you want to talk about PIP coverage?
Yes. Kentucky has PIP, or personal injury protections, what PIP stands for. Also referred to as no-fault benefits or basic reparations benefits, 3 different terms for the exact same thing. And what that is if you're involved in a motor vehicle collision, then the vehicle that you're in at the time of the collision is responsible for the first $10,000 of your lost wages or medical bills. If you're a pedestrian, then the vehicle that makes contact with you is the one responsible for that first $10,000 of medical or lost wages, or combination of the two. And so, yes, your medical bills, a lot of people are concerned about the medical costs, and they don't have the money to go to the doctor. They've not met their deductible, and money's tight, so they don't want to seek medical treatment. With a car wreck, you don't have to worry about that because PIP will pay the medical bills in that regard. So you can go ahead and seek the medical treatment and let that insurance cover the medical bills to at least initially, and then you can get that treatment that you need to get.
Right. And the nice thing is everybody in the car individually gets their own up to $10,000 of coverage there. It's not like you have to split it amongst yourselves. So every passenger is also covered by this PIP coverage, which is a great benefit to them. And then there's always the question, well, Jeff, if it's my car, I'm the driver, and I make a claim for PIP coverage, and I've got some other people that do the same, are my rates going to go up?
Right.
There's a good answer to that.
Yeah, there is, and it's no, it will not go up. There's a regulation directly on point in Kentucky that prohibits them increasing your insurance rates for accessing PIP or uninsured or underinsured motorist coverage. So you're good from that perspective. You don't have to worry about that there. Now, rates go up often
for other reasons.
Nearly every year your rates are going to go up a little bit. So I have people think, well, I used my PIP and now my rates went up. Your rates were going up anyway. That had nothing to do with using the PIP.
That makes sense. Okay, so again, you've got up to $10,000, sometimes more if somebody's carrying extra coverage. You can increase that.
You can increase it. You can purchase what's called added reparations benefits or added PIP and provide even better protection for you and your family. And if you purchase that added coverage is available for everyone in the vehicle as well. Right. So if you purchase another $10,000 of added PIP, then everybody in the vehicle has $20,000 of PIP.
Right. The original 10 plus the additional 10.
Correct.
Yeah, that's fantastic. And again, because as Jeff explained earlier, we refer to it a lot of times as PIP, personal injury protection, but it's also called no fault. And Kentucky is a no fault state. And because you don't have to prove negligence for the PIP benefits, that's why your rates aren't going up. You're not admitting that you were guilty or that you were negligent in causing the actual collision.
Correct. And the way it is in Kentucky, the PIP benefits or no-fault benefits are the only part of Kentucky law that is no-fault. Kentucky's referred to as a no-fault state. That's kind of a misnomer in my opinion, because the only aspect of it that is no fault is the PIP benefits or no fault benefits. But what happens there, and another reason why it does not cause your rates to go up, is after later on, your insurance, if you weren't at fault in causing the accident, the at-fault party's insurance company ends up reimbursing your insurance company what it's paid out in PIP benefits. PIP is designed, and no-fault benefits are designed to make sure everybody who's involved in the accident can seek medical treatment for their injuries without the insurance companies arguing between themselves over who's at fault. Kentucky legislature said, they can fight that out later.
Yeah.
We make sure people's medical are taken care of initially. They can get the treatment, partly because they realize, too, I'm assuming that early treatment leads to better results there. And so we let the people get the treatment that they need for this, and then the insurance companies can fight it out and determine who's at fault later. And then the at-fault driver's insurance reimburses everybody else's PIP at that point.
And this PIP claim that we're actually talking about in this answer is actually different from the overall claim. You're still going to be negotiating and possibly litigating the actual car wreck.
Correct.
But this little bit of coverage for medical benefits is a good thing.
Correct. Absolutely.
Okay.
Yes.
Okay.
Yeah.
So as we return back to the outline here, what is the fourth thing that people should not do after a car wreck?
You should not give a recorded statement to the other insurance company without consulting an attorney first.
And why is that?
Well, first off, the insurance adjuster who is taking the recorded statement is trained in the law. They're trained in how to handle these cases. So that adjuster will, or claims representative, whatever they want to call themselves, will answer or ask you questions. And they'll start off and act like they're your friend. They're not your friend. They're an employee of the insurance company, and they will phrase questions.
Who's representing the other driver.
Who's representing the other driver, and they'll phrase their questions in ways that will make it look as though you're the one who caused the accident, and they're going to try to talk about prior injuries and try to focus on that to get it, say, well, this was, you already had a lot of these problems and this was just a temporary aggravation. They're going to try to downplay your injuries. They're going to try to downplay the fault of their person through this statement, try to get you to agree on things. Well, the conditions were bad that day. It was hard for anybody to see because of the fog. You having trouble seeing, and a lot of things they will do to try to minimize what they have to pay out to you later on. That's what their goal is to minimize how much they have to pay out to the injured parties. And
ultimately, that's their job.
Yes.
I mean, that's why they're there. And unfortunately, when you're talking to these people, and again, they're going to be nice and polite generally, and you're thinking you're having a good conversation, and you just may say something out of context that suddenly, as Jeff said earlier, it's on tape now, and now you got to deal with it. You were just talking. Yeah. You didn't realize from a legal standpoint, you're making statements that probably you ought to have your attorney with you.
Right. Exactly. Yeah. And that's, you have your attorney present with you, or at least consult with an attorney before you give that statement. And, as I think I've mentioned before in a podcast episode, frequently after I get involved, I have the claims representatives ask me to take a recorded statement of my client. And usually I'm fine with that as long as I'm present and involved in it and I've prepared my client ahead of time. But I also always say, we're fine with giving a recorded statement, but at the same time that we give, you ask my client and take a recorded statement of my client, then I want your insured to be available and me to take a recorded statement of their insured about the wreck and what happened. And almost always they decide that they no longer need the recorded statement of my client.
Right.
When I email them back that response, I can't recall one time where they said, okay, we'll make our insured available and we'll take your insured at the same time. I can't recall one time that's happened.
In 33 years.
In 33 years.
And again, that just goes to show that, you know what, these statements are being recorded for a specific purpose. They're trying to get you to say something that you don't realize how dangerous it can be, you know, to your actual claim.
Right. And they realize that if I'm taking a recorded statement of their insured, I'm going to do exactly what they're trying to do to my client in that recorded statement. I'm trying to get the facts, but I'm also trying to get their insured to admit he was at fault or he or she was at fault or whatever it may be. A lot of times I'll get them to admit my client was clearly hurt at the scene and things of that nature, if in depositions, because they never let me take a recorded statement of their insured. But they realize the damage that can be caused through a recorded statement. And so that's the reason they don't want their insured to be subjected to a recorded statement in that regard. But that's also the reason why they want to take a recorded statement of the injured parties. So.
No, that makes a lot of sense. Let me ask you this. If I've been in a wreck, and does my insurance company ever want to record my own statement kind of internally? I mean, does that ever come up?
Some do, like when you file PIP, sometimes they will want to take a statement of you to get information from you. A lot of times it's just on the PIP application and that's it. Tell them what body parts were injured, et cetera, what doctors you've seen. For that, it's rare that they will want to get a recorded statement. I think it's happened in the past, but it's not something I see very often at all.
So generally it's the other side wanting to record you so they can use it against you. Okay.
Yeah. Now, if at times I will see, I have seen them when there was at least a question as to who was at fault. Mm-hmm. And my client's insurance company also has an adjuster that is handling any claim made against my client for people who think my client was at fault. Then that adjuster will want to get a recorded statement of their insured in that situation. But that's a situation where my client could potentially be at fault because in Kentucky, as we've talked about before, Kentucky is comparative fault state. So you can have more than one person at fault in causing a car wreck. And so in that situation, sometimes the one who's handling the liability claim for my client will want a recorded statement. Okay, that makes sense. And friends, we're referencing topics that we've addressed in previous episodes. So if you go back to the show notes, and that's all the writing, all the paragraphs down below where you're actually listening to this, it's like a description of what we're talking about. I'm going to put links to those other related podcast episodes. So if you're interested in a topic or you want to know more about it, just click on that link and you'll be able to go right back to the original episode, and it'll give you some other valuable information. Jeff, what's next on the list of the top 5 things you should not do? The last is do not accept a quick settlement. I cannot tell you how many times I've had clients come in and potential clients come in. Some have already accepted a quick settlement and there's not anything I can do about that. And others have been offered a quick settlement in the case, and luckily they came to me before they accepted it. And so you don't want to accept a quick settlement. That's sometimes even in the recorded statement where my client's given or potential client's given a recorded statement. And in that recorded statement at the end of it, they'll say, well, would you accept, if we pay some of the medical, and would you accept $2,000? And if you say yes, you probably just settled that case. Yeah, without knowing it. Yeah, without realizing that's what you're doing. And so don't say yes to any kind of an offer whatsoever on the phone or in writing or anything else until you've talked to an attorney. And you don't want to do it quickly because, 2 weeks, 3 weeks after the accident, you have no idea what your injuries are truly going to be at that point in time. And so you don't want to settle quickly. I had some people come in one time where the insurance adjuster said, well, we're going to take care of your property damage. The accident, it was clear liability accident. There was no fault on behalf of my client. So they're going to fix the car, basically. Yeah, they're going to fix the car. The other driver, my client had the right of way, him and his passenger in the vehicle. He had the right of way. A car had a stop sign pulled out in front of him, even though he didn't have a stop. He was on a major road. And they told him, said, well, we'll take care of your property damage. We'll pay up to $10,000 of your medical bills, and we'll also give you an additional $2,000. And told both of them this in it. And this was like 2 weeks after. First off, they had to pay the property damage. They weren't offering anything.
I was going to say, it sounds like a generous offer.
Well, it sounds like it. The $10,000 of medical PIP's paying, they're obligated to reimburse PIP, which is all they were agreeing to do in that regard. The law requires that, so they weren't really offering the client anything.
It's money you're already going to get.
Yes. And then, so they were offering $2,000. The clients had gone to the emergency room and had some medical treatment or still having problems. But they were both younger individuals, and $2,000 sounded like a lot of money.
Yeah.
And so they were real serious about potentially taking it. And after talking with me, they realized, hold on, they didn't really offer us anything here.
Yeah.
Because they thought they were getting the property damage plus $12,000, 10 of medical and 2 more. And if they didn't use the 10 medical, they thought they were going to get to keep the additional amount in that, because they weren't understanding what was being done there. And luckily they came to me beforehand and they did not do that. And, but you've got situations frequently where early on they will make we'll offer you $1,000, $2,000, $2,500, because they know, statistically speaking, they're coming out a lot better off, even if there's some claims that the damages may not be justify that. But frequently the damages are going to be much greater than that, and it's to their best interest if they can get people to agree to do that.
Well, and I would think if I've gone to the ER, I've had some exams, maybe I'm dealing with some stuff, there's no guarantee that, okay, I'm good now. You could have to have a surgery down the road. You could have to have some other treatment, some physical therapy.
Right.
You've lost time at work. You've got all these other things that could come into play that if you've settled the case, they're off the hook, right?
Correct.
If you've said yes, they're off the hook for that.
Once you've settled, and then you've probably, if you do that, you don't know about underinsured motorist coverage. And so you're going to take the $2,000, sign the release, send it back into them, and then you've released your underinsured motorist claim at that same time without realizing you even had an underinsured motorist claim.
And for the audience benefit, how does an underinsured motorist benefit that policy that we've talked about in the past? How does that come into play in this situation, and why is that so important?
Well, when you purchase insurance, you can purchase what's called underinsured motorist coverage, and you should be purchasing underinsured motorist coverage. What that is coverage that protects you and the occupants of your vehicle. So you and your family are protected from that coverage if you're involved in an accident that's not your fault, or if they're passengers, even if you are at fault, that protects your family even in that situation, potentially. And the at-fault driver's insurance isn't enough to satisfy all of your damages. So if the at-fault driver has $25,000 of liability coverage, bodily injury coverage, and your medical bills are $30,000, well, that doesn't even cover all your medical bills.
Right.
So your damages are much greater than the $25,000 of coverage available from the at-fault party's insurance. So then you can look at collecting the additional damages from your own insurance company, and then they would potentially have a right to go back against that at-fault driver. But it's them trying to chase those assets, not you trying to chase assets. So,
and again, that's a policy that you're already paying for through your automobile insurance premium to your own insurance company.
Right.
So the fact that they're paying you back on that policy, that's what you're paying for.
Right. Now that's optional coverage.
Yeah.
You have to purchase that coverage.
And that's the UIM coverage, right?
It's referred to as UIM, but it should say underinsured.
Yeah.
You've got uninsured and underinsured, and underinsured is optional. Uninsured is mandatory in Kentucky.
Right.
You've got uninsured if you're insured through Kentucky. But underinsured is not mandatory. It's optional. Most policies have it. But if you need to make sure you do, because if you don't have that, then you definitely want to be getting that coverage there. But there's a certain process that you have to go through to protect your underinsured motorist claim when you accept the liability policy limits or the settlement with the liability carrier. And if you don't go through that process, then you've released the claim against your underinsured motorist carrier as well.
Okay. And so again, you've got the PIP insurance, you've got potentially this UIM coverage,
Right.
and then whatever Jeff or some other attorney can actually recover in terms of the actual claim itself.
Right.
So there's a lot of layers to this. And the first thing you ought to do is probably talk with an experienced attorney.
Right.
Jeff, you've got 33 years down here in Western Kentucky. You've handled cases all over the place, but primarily you're in the Western Kentucky region. You've got 2 offices. You want to tell us about that?
Yeah, I have my primary office here in Murray, Kentucky. I've been here since '92.
Yep.
And then I have a satellite office in Hopkinsville where I see patients. Sorry about that. Where I see clients at as well. I've always had a lot of clients up in that area.
Yeah.
And so it just allows me to service them better in that regard. As you know, I have a motto for my office that we provide small town service and deliver big city results. Having that office up there allows me to provide better service for my clients in the Christian County area and even further east, I guess, of Christian County. I have a lot of clients up in the Bowling Green area as well, and that allows me to provide better service for them. I've had it for a few years now, and I like the office up there.
Yeah, we've actually done a podcast episode or 2 up there. So, Jeff, if somebody wants to get in touch with you, the good news is, regardless of which office, you've actually got one single phone number that you typically use.
Correct. Yeah, they got one number. It's 270-753-0053. If you call that number during normal business hours, you should get a live person to answer the phone. And it's not somebody at a call center somewhere else. It's somebody that actually works in my office. If you have any questions, give us a call. We will they'll get some information and we'll see what we can do for you.
Outstanding. Well, friends, I hope you found this interesting. Again, today we talked about 5 things not to do at the scene of a car wreck or a car accident. And hopefully it's some valuable information. And what Jeff always does a good job of is actually kind of explaining the why behind the advice. Sometimes you get a tip and, okay, that doesn't always make sense. But the reason we're doing these podcasts is to break down these legal issues so that they're just understandable and it kind of makes sense. And you're probably more apt to remember it if you understand the why behind it.
Right.
Yeah, I think so. So. So once again, we'll be back in a couple of weeks. Thanks very much for watching. We'll talk to you soon.
Thank you.
Take care. Bye-bye.
Thank you for listening to the Roberts Law Office Injury Podcast. Jeff will return in 2 weeks. Until then, he invites you to visit jeffrobertslaw.com and follow his firm on Facebook. At the Roberts Law Office, you'll find a history of small town service and big city results.